Assalamualaikum warahmatullahi wabarakatuh. This is a Zoom recorded lecture for the topic General Defenses in Thoughts for Law of Thoughts 1, Law 1510. This is actually the final topic for the syllabus for Thoughts 1. So the final topic is General Defenses, but it covers a long list of defenses. So the lectures actually, they are divided into two parts, part 1 and part 2. And part 2 alone, it has a few videos to cover all those in part 1. And later it will be followed by part 2. Okay? Part 2 will be the final of the final parts of the final topic. So for part 1, basically, okay, let me go to the background first, okay, before we go to the division of the topic. So why do we bother? Okay, what's the connection or relevancy of the topic defenses here? So as we started from the very early semester, okay, we were discussing about the right to compensation, okay, under the law of tort, which is given to the plaintiff, and usually plaintiff is claiming against the defendant. And how does the plaintiff do it? Okay, by filing a legal suit, or we call it as legal action. And then in order to do so, okay, the most important thing that plaintiff has to do is that plaintiff must be able to cite or must be able to quote, okay, legal grounds as the causes of action. So there must be cause of action, then only plaintiff can proceed with the legal action. So in the early part of the syllabus, okay, we covered a lot for the topic negligence, okay, and we discussed right from the duty of care, breach of duty, and causation, okay. And then there are also some other causes of action which we have yet to cover, but it will be covered in thoughts 2 later. Okay, it all revolve around intentional thoughts. For example, trespass, nuisance, defamation, wrongful imprisonment, and some other intentional thoughts. Okay, all this while causes of action usually it has to be proof on the part of the plaintiff. So remember, torts is essentially between individuals. It's a civil action. So defendant also has the opportunity, the chance, the legal right to defend his case, defend himself. So how does he do so? By quoting, by citing certain factual and legal grounds. And these grounds, which is available to the defendant most of the time, they are called defenses. So that's our topic, basically. And let's say the court decides to approve or to accept such a defense as forwarded by the defendant, then what's the legal consequence? It can eliminate or it can reduce liability. Meaning that here it's possible for defendant to be absolved from liability if he can prove the defenses on his part, okay, to defend the cause of action, the claim brought to against him, okay, by the plaintiff. Okay, so this is the division of the topic. For part 1 of the topic, basically it is meant to cover the first 3 defenses, which are usually the typical or the common one. Okay, it will start with the volenti non-fit injuria, or the acronym is VNFI, and then followed by illegality, and then lastly for part 1 is inevitable accident. Part 2 later will cover mistake as of guard, private defense, necessity, and statutory authority. That one will be covered under videos for part 2. So for today, okay, right now, we are going to cover on volenti non-fit injuria, but up to consent in sport. So that we won't be covering that. It will be done for second video. Okay, for first video, we are going to cover everything about, not everything, but almost substantial part of volenti non-fit injuria. So that's the term, okay, the phrases, which is actually, it's not English term here. So for volenti non-fit injuria, this is the scope, okay, that we are going to discuss. First, we are going to cover on the definition. We are going to talk about the meaning of volenti non-fit injuria. And then later we'll proceed with elements to prove. What are the elements under volenti non-fit injuria? Basically, there are two important elements, knowledge and consent, and both must be proved. And the last part of our discussion for this volenti non-fit injuria is the scenario, some of the typical or common scenario. For example, it involves employment or workman cases. It involves also driver passenger cases, sport cases, and also rescue cases. And this is some of the leading cases, landmark cases that we are going to discuss together. We'll start with ICI, Imperial Chemical Industries Limited and Shadwell, and later Smith and Baker and Sons, and the local case Kanaga Sabapati and Narsingham. And then coming back to common law, Nettleship and Western, and Bowater and Rowley Regis Corporation. This is some of the cases, but actually there are more cases, especially for the specific scenario of sports, okay, consent in sports and consent for rescue cases. Okay, we go to the definition. What's the meaning of the word volenti non-fit injuria? So generally, it means, okay, volenti non-fit injuria, it means, or it denotes consent, okay? And then it also denotes, okay, it also means voluntary assumption of risk. You consent to the risk, and the plaintiff consents to the risk, and plaintiff also voluntarily, okay, assumes the risk, okay, take the risk voluntarily. And then this is the quotation or the explanation by Lord Herschel in the case of Smith and Baker. We're going to discuss this case later. Lord Herschel said that one here usually refers to claimant or defendant as plaintiff. One who has invited or assented to an act being done, okay, towards him cannot, when he suffers from it, complain of it as a wrong. In that here, if he consent, if he has given his consent, okay, for whatever being done towards him, later, if he suffers certain injury or certain losses, then actually he cannot complain about it, okay? Complain about what he has consented, what he has given consent for that particular act. So that's basically the concept of volenti non-fit injuria, or the consent or voluntary assumption of risk. So meaning that here it's possible to equate volenti non-fit injuria with consent. That one is the plain meaning. But when we talk about the interpretation by the court, okay, occasionally courts give different meanings. So meaning that here it has broader interpretation. Okay, it is stated in this case, all right, in the case of Freeman and Home Office number 2, reported 1984. This is the quotation by Sir John Donaldson, MR. Okay, he said that consent applies, okay, when the plaintiff does give consent. So that one is straightforward, okay, understandable. But as far as volenti non-fit injuria is concerned, okay, actually it has broader interpretation or meaning. So volenti non-fit injuria, VNFI here, it applies when he does not consent. I mean, apparently there's no such content. There's no such consent. But the way he carries himself, but still conducts himself as to lead, okay, the defendant to believe that he does. The way he reacts, the way he acts, basically it gives the impression, okay, on the part of the defendant that actually plaintiff consent, okay, to the act or to what happened to him, okay, to what is being done to him. So meaning that here, from this particular quotation, okay, consent can be implied, can be inferred from conduct, okay, from the act. Or sometimes, if it is straightforward case, then it is expressed in words. This is some of the common example or scenario here. For example, participating in boxing match, that one is in sports, okay? Or in medical cases, okay, medical situation, presenting one's arm for injection. I mean, you hold your arm and then the doctor can give you injection. So you consent to the risk, okay? You consent to the act of injection. Or even smoking cigarette, like the picture there, okay? Meaning that here, if the smoker, okay, if anyone were to smoke, then he knows the risk and he consent to whatever risk later. It could be long-term effect, but then basically he consent to it. Okay? He consents to it. Okay, now we go to the requirements. So we are done with the definition. So we have plain definition, we have interpretation from the case law, okay, by the quotation by the judge. All right, so what are requirements to prove a volenti non-fit injuria? So generally, defendant will have to prove two things together. Okay, cannot prove either one. The first one, first, on the part of the defendant, because this is a defense. Okay, defendant is the one who has to prove on the part of the plaintiff. So defendant must prove that plaintiff knows about the risk. So it's about the knowledge. And together with the knowledge, that plaintiff consents to such a risk. And that is basically the, I mean, the elements here are extracted from from many cases. So this is one of the cases. The case is Letang and Ottawa Electric Railway Company 1926. Okay, here, especially the one that I make it in blue font. Okay, here, okay, they must obtain the finding of fact, okay, that the claimant, see, this is the one that defendant has to do. Okay, claimant or the plaintiff freely and voluntarily with full knowledge, okay, impliedly agreed to incur it. So plaintiff knows about it and consent to the risk lah. So that's basically the elements that we extract from this particular quotation. Okay, we go to the case. This is one of the landmark case for volenti non-fit injuria. So you'll come across this case in many textbooks or even in any references that you Google online. Okay, here. The case is ICI, that's the acronym, but the full name of the company or of the party here is actually Imperial Chemical Industries Limited and Shadwell, 1964. So it involved two plaintiff here. Okay, plaintiff and his brother. So they were certified and experienced shot fire. So that's basically what's their job. Okay, here what they do, what they did for as to earn income. Okay, and they are employed by ICI Limited. Where did they work? Okay, here they were working in a quarry, okay, and owned by the employer. And then what's their job scope? Okay, what did they do every day? So part of the brother's work, both of them, okay, plaintiff and his brother. So part of the work included wiring up detonators, okay, and checking the electrical circuits, okay. And there was an old practice, okay, where a galvanometer in the picture, okay, galvanometer was applied directly to each detonator for testing purposes. And actually, the way that was being done, okay, is known to be dangerous, and the law doesn't allow it. Okay, it was outlawed by statutory regulation, prohibited actually. And one day, okay, when they were doing their work here, okay, by using this old practice, which was prohibited apparently, the explosion took place, okay, and then plaintiff suffered injury. So plaintiff now claimed his brother was to be blamed for the explosion, and brother is also the employee. So now the plaintiff suing the brother together with the employer, because later we learn about vicarious liability. So usually if the negligence is caused by the employee, so the plaintiff can sue the employee, the one who caused negligence, together with the employer, okay, based on vicarious liability. And then trial court judge, okay, here he awarded half of the total amount of damages. So meaning that here he succeeded in the claim but cannot get the full amount, couldn't get the full amount, but he succeeded to claim half of the compensation that he asked, okay, when he filed the suit. But the defendant appealed. That's why the case name is ICI and Shadwell. Actually, before the appeal, it is Shadwell and ICI. Okay, so defendant appeal. And then this is the cause of appeal, observation. Okay, the court said that plaintiff and his brother were both expert. Okay, they are not the normal or ordinary worker. They freely and voluntarily assumed the risk involved in using the galvanometer, and there was no pressure from any other source. It was their own choice. Okay. And actually, there's also evidence showing that actually both of them were specifically warned. They received warning, okay, about complying with the new safety regulations. They can't be using, they are not supposed to use the old methods of, using the old practice, okay, of those procedure. They knew about it better, okay. So because of that, okay, the court said that the defense of volenti non-fit injuria will only apply when there is true and free consent to the risk. And the court found that yes, okay, when they assumed the risk, when they knew about it, they had consented to the injury. So because of that, defendant employers were not vicariously liable. No liability can be imposed on the employer. They assume the liability on their own themselves, okay. So that's basically the case of ICI and Shatwell. So this is the example of volenti non-fit injuria, which was accepted, okay, by the court. Okay, the defense was accepted by the court. So eventually, plaintiff could not claim, okay, for the compensation. Okay, let's go to the second case. We'll try to see in what way they differ. They both involve, the defense of volenti non-fit injuria. The case name is Smith and Baker and Sons. Actually, this is the older, okay, which was decided earlier, 1887, 19th century case. And even also in 1981, okay, appeal case. So plaintiff or servant of the defendant. So plaintiff was employed by the defendant. Defendant was railway contractors. So what's the plaintiff job? Drilling holes in rock cutting. So more or less, it's like in the picture, okay? And plaintiff worked in the condition where there was continuous stone removal work operating by crane over his head. So the crane keep on moving over his head while he was doing his work drilling holes in rock cutting. And one day, a stone fell out of a crate. Okay, crate is like a box or a case, okay, which were carried by the crane over his head. So it injured plaintiff. So now plaintiff took legal actions against the employer. Now plaintiff sued the employer for the injury that he suffered. And this is observation by the court, because now the employer was trying to argue on the defense of volenti non-fit injuria, but the court said that mere continuance of work did not indicate that plaintiff acted voluntarily. The fact that he kept on doing his work daily, it doesn't mean that he did the work voluntarily. Okay, and the question, the issue here is not whether he voluntarily and rashly expose himself to injury. But the real issue is now whether he agreed that if injury should befall him, it did. Okay? It befell him. The risk was to be his, not his master's. And then so whether working under these circumstances is meaning here all the working in such a high risk situation here, is it assumption of risk here? It depends upon the nature of the risk, and it depends on the workman's the employee's connection with it, as well as other various circumstances. So it's not as easy to say, oh, you work in such a condition, you continue working, meaning that here you assume the risk, you consent to the risk. It's not that straightforward. It's not as straightforward as that, okay? And this is decision by House of Lords, okay? And this is majority decision. It's not unanimous, it's majority, because we also have Lord Bramwell for dissenting judgment. So meaning that here, the House of Lords, they reverse decision by Court of Appeal. So Court of Appeal allowed the claim, the Court of Appeal held that volenti non-fit injuria was applicable, but House of Lords said, no, we cannot apply the defense of volenti non-fit injuria on the part of the employer. The House of Lords said that the mere fact that the plaintiff undertook and continued in the employment with full knowledge and understanding, okay, here, it doesn't prevent him from recovering, okay, from getting compensation. And then the evidence, okay, will justify a finding, okay, this is observation, plaintiff actually did not voluntarily undertake the risk of injury. So we cannot allow, okay, application of volenti non-fit injury. So action was maintainable. The plaintiff was allowed to get the compensation, okay, based on his legal action against the employer. So the court didn't accept the defense of volenti non-fit injuria. Okay, let's go to the local case. Kanaga Sabapati and Narsingham, 1979. It involved a very unique job or work here, which is not so common, I think. Okay, maybe it is in rural areas, it's quite common, but in city, unlikely for us to see such a work here. So what's plaintiff? Plaintiff was a toddy capper. It's the picture. You can see the picture. So he was required by the employer, defendant, to tap 25 coconut trees twice daily. So maybe morning and afternoon, or maybe evening. And then the toddy tapper here, the plaintiff, he had complained several times. Very important. Okay, this is part of the evidence. So complained several times about the slipperiness of the steps. due to mossy growth and rain. So it's very, very slippery, okay, for him to climb up, okay. But employer just ignore, okay, his complaint. So employer, defendant did not take any action, okay, to improve the situation, to make sure that, I mean, it was safe for him to climb up, okay, to do the toddy tapping. And one day, plaintiff, the toddy tapper, he fell and he injured himself. Now he sued the defendant. But defendant said, you choose to continue the work. So actually you give your consent to it. Okay, you know it's very high risk, but you still continue to work. But the court disagreed. Okay, and the court held the employer liable for negligence. Okay, what's the negligence here? Failure to provide a reasonably safe system of work. And then the court said plaintiff was aware, yes, he was aware of the risk, but he did not consent to it. And that's why we didn't allow voluntary non-fit injury to be applicable in this case. So actually the main issue here, the question, or how do we decide? First, we need to know, okay, whether there was a knowledge of the risk. Basically, yes. But then was there a consent to assume the risk? No. Because why? The fact that he complained, not one time, okay, many times, okay, several times. So that's indication that indicated that actually there's no consent to assume the risk. He knew, but he can't do much about it. Okay, he need to continue working. So let's go to another case, Nettleship and Weston. This is common law, also another landmark case on voluntary non-fit injury, 1971 Queen's Bench. It involved plaintiff and defendant. Defendant is the one who asked the plaintiff to teach her, okay, a lady, okay, to drive. Okay, so a new driver, basically, it's about to learn how to drive, driving lesson. So defendant asked plaintiff to teach her driving. And before plaintiff agreed, okay, plaintiff actually was not so sure about it. So she inquired, okay, about the car's insurance policy. Meaning, yeah, oh, is your car protected under insurance whatsoever in case anything happen later, okay? And during one of the lessons, meaning it's not one lesson, and it's not once only, okay, many times actually the lesson was done, okay, the lessons were done. So defendant lost control because he was still learning, okay? Defendant lost control of the car and caused an accident, so injuring plaintiff, the so-called driving instructor here, the one who gave the driving lesson. So defendant argued that plaintiff was well aware of her lack of skill. Oh, you know that I don't have the skill of driving, so you know it's a very high risk for you to teach me. And the court should make allowance for her. The court actually should let her free, okay, since she could not be expected to drive like an experienced motorist. So accident is something which is foreseeable, basically, okay? And you knew about it. That's the argument put forward by the defendant, okay? But the court was in favor of plaintiff and held that voluntary non-fit injury does not apply in this case. Because why? Plaintiff did not consent to the injury because the fact that she inquired before, before giving out the driving lesson. So she didn't consent to the accident later. So again, the same question, was there knowledge? Yes, there was. Was there consent to assume the risk? There wasn't. Okay, that's why the court didn't accept the argument of voluntary or the defense of voluntary non-fit injury in this particular case. So similar to earlier case. So, the decision or observation is similar to this Kanaga Sabah party. Okay, but this one happened earlier. Okay, and this is common law, and that one is local case. Okay, another case here. I think the last case for this video number 1. Okay, for general defenses. The case is Boater and Rowley Regis Corporation, 1944. It involved a carter, another unique job, okay, or career here. Those days in 1944, okay. Plaintiff, so he worked as a carter, or actually carter is a cart driver. Driving a cart like that, okay, pulled by horse. So he was employed. What's the job scope here? What he's supposed to do? So he was employed to collect road sweepings, okay. I put in the definition, okay, road sweepings by a municipal corporation. So that's basically his employer. And the plaintiff, the cart driver here, he was ordered by his foreman, by his supervisor, to take out a horse, okay, which to the knowledge of both of them, meaning that both were aware, okay, his supervisor was aware, he himself was aware, this particular horse had run away on at least 2 previous occasions in the past, okay. is not that tamed in the horse here when driven by some other fellow employee. So the cart driver, he protested, meaning that he didn't agree, to do the work. But the supervisor said, the foreman said, well, you don't have any other option. This is an order of the borough, okay, or town surveyor, by their boss, by their superior. They have to do the work, okay, with the horse, no other option. And some weeks later, the horse ran away because the horse ran away previously, and when the plaintiff used the horse, okay, the horse ran away. And because of that, the plaintiff was thrown from his cart and he suffered personal injuries. Now, plaintiff took actions against the corporation, the employer, and he alleged that they had failed in their duty to provide him with the horse, okay, which was safe. The horse was not safe, and the horse was not suitable for the work which he had to perform. And this is the court's observation, and because the employer raised the defense of volenti non-fit injuria, okay, and the court said a man cannot be said to be truly willing. You cannot say, oh, he is willing, that, you consent to the risk unless he is in a position to choose freely. So in this particular situation, he wasn't given any choice, any option. Okay, he must use the horse, which is not safe, which is not suitable. And the judge also said, okay, a corporation carter or dustman is not like a horse breaker because he is also a horsekeeper. It's not part of his duty to break or tame the horse which draws the dust cart. Here the judge was trying to differentiate between a carter, okay, cart driver, and horse breaker. Okay, the job scope is not to tame, okay, the horse. Okay, it's just to do whatever job in respect of dusting or carter. Okay, to do the road sweeping, not to tame, okay, to tame or to break or tame the horse. Okay, and the court also said, for this maxim or doctrine to apply, it must be shown that a servant, employee, who is asked or required to use dangerous plant, like the horse, okay, which is not so safe here, so is a volunteer in the fullest sense. Obviously, it's not, okay? So the court said the evidence in this case, in Bawata's case here, fell short of that, okay? So in court's opinion, the plaintiff was entitled to recover. So what can we learn from this case? This is the ratio basically here. So a person is said to be voluntarily assuming the risk if he is in a position where he has a choice. So in this Bawata's case, no choice actually, no other horse available for him to choose. That's the only horse available. So he protested. Okay, he was not agreeable, but he still has to proceed with using the horse. And he must have full knowledge of the circumstances in which he has to make the choice so that he may make a reasonable choice. So he wasn't given the opportunity to make reasonable choice. So eventually, volenti non-fit injuria was not applicable in this case. Okay, that will be covered in the second video of this general defenses part 1. Okay, so I stop share for a while.